The following section includes information on whether workers are classified as independent contractors or employees. This information is included to assist in your overall understanding. Please remember that these decisions require legal determinations, and ADP does not provide legal services. If there are questions about whether workers should be classified as independent contractors or employees, please consult with HR and legal resources. When a company hires a worker, it must determine how the worker should be classified, typically as an employee or as an independent contractor. This determination is needed to properly handle payments the company makes to the worker for services performed. Payments made to those classified as a common law employee are subject to employer tax responsibilities. Independent contractors are not subject to employer tax responsibilities. Therefore, it is less costly to the employer when a worker is classified as an independent contractor. To avoid companies misclassifying workers and ensure employers remain in compliance, the IRS has set guidelines for determining this classification. The Department of Labor has its own guidelines, and most states have a test for determining whether a worker is an employee or an independent contractor. It is the responsibility of the employer, and in their best interest, to accurately classify their workers. Since misclassifying a worker can result in revenue loss for the government, agencies pay close attention to this and conduct audits to ensure employers are compliant. Before we explore the guidelines for classifying workers, let's take a look at some key terms and definitions. Employee or common law employee is someone who performs services for an employer is considered an employee if the employer has the right to control what work will be done, how the work should be done, and provides the tools and equipment needed to do the job. Independent contractors are people such as lawyers, contractors, subcontractors, and auctioneers who follow an independent trade, business, or profession in which they offer their services to the public. The employer will typically pay a contracted rate for the independent contractor to provide a service. The employer does not have control over how the work is done and does not provide the tools and equipment needed to perform the job. There are 3 tests that may be used to figure out how to classify a worker. 1. Economic Reality Test, or ERT. The U.S. Department of Labor has a new rule for classifying workers under the Fair Labor Standards Act, FLSA. This rule considers 6 factors when deciding a worker's classification. These factors are important in looking at the overall circumstances. 2. Common Law Test. The IRS suggests businesses consider common law rules to determine the relationship between a worker and a business. This includes looking at behavioral control, financial control, and the relationship of the parties. 3. States ABC Test. Different states have different laws about independent contractors, unemployment compensation, workers' compensation, and state tax collection. Many states use the ABC Test, which has 3 factors for a worker to be an independent contractor. These tests are guidelines and do not contradict one another. If there is confusion, request a determination from the IRS. Workers and businesses can file Form SS-8 to ask the IRS to determine if a worker is an employee or an independent contractor. You can then use this decision to correctly file federal income tax and employment tax returns. Let's take a closer look at the Economic Reality Test. Department of Labor shared a way to figure out if a person is an employee or an independent contractor. This new rule updates how the department guides us in deciding who is an employee or contractor under the FLSA. There is no one clear rule for classifying a worker as an independent contractor or an employee. The Department of Labor developed the Economic Reality Test to provide guidance on classifying workers accurately under the FLSA. Instead of relying on labels or contracts, this test looks at the actual situation. It checks whether a worker is economically dependent on an employer by considering various factors. Courts and the department have always looked at these factors to decide if someone is an employee or a contractor. When figuring out if a worker is an independent contractor or an employee according to the FLSA, the economic reality test examines 6 key factors. Let's break them down. 1. Opportunity for profit or loss depending on managerial skill. Ask if the worker has a chance for profit or loss based on their managerial skill. Look at factors like negotiating pay, choosing when and how jobs are done, and efforts to grow their business. If there's no opportunity for profit or loss, it leans towards the worker being an employee. 2. Investments by the worker and the potential employer. Check if the worker's investments are capital or entrepreneurial. Compare the worker's investments to the employer's overall business investments. Similar types of investments favor independent contractor status. 3. Degree of permanence of the work relationship. Assess if the work relationship is indefinite, continuous, or exclusive, favoring employee status. If it's non-exclusive, project-based, or sporadic, it leans towards independent contractor status. Consider fixed periods of work, but seasonality alone doesn't determine status. 4. Nature and degree of control. Examine if the potential employer has control over the work and economic aspects. Reserved control, even if not exercised, is relevant. More control by the employer suggests employee status. More control by the worker suggests independent contractor status. 5. Extent to which the work performed is an integral part of the potential employer's business. Ask if the work is critical, necessary, or central to the employer's business. If yes, it indicates employee status. If not, it suggests independent contractor status. It depends on the function performed, not the individual worker's importance. 6. Skill and initiative. Check if the worker uses specialized skills contributing to business-like initiative. No specialized skills or dependency on training may indicate employee status. If the worker brings specialized skills with business-like initiative, it suggests independent contractor status. No single factor decides if someone is an employee or contractor. You have to look at the whole picture. The importance of each factor may change based on the specific details of the relationship. Other factors might also matter, especially if they hint at the worker running their own business rather than relying entirely on the employer.